Your Honor, this is not an objection. It's an humble plea that counsel shares the decision with us, and that if he's generous enough, that he also points out the paragraph that he's paraphrasing, so that we are able to respond there.
Your Honor, we have already filed our list and digest of authorities dated in 16th of June 2025, and you can confirm, Your Honor, that they are there. The decisions and everything, we have already finished. Yes, sir. It's the last decision. Cancel the one which is on the thing is down.
Sorry. I am looking at your document, sir. I am alert.
Thank you.
The document written respondents list and digest of authorities.
Yes, you are.
I am looking for Mercy Jebet. You are it in the
There is another one which is look. It's not. Is the one you are holding.
Thank you. No, this is the list. It does not have Mercy Jebet. Does it have it?
You already have an authority. The one next to your phone.
You know what we are informing the court is that we didn't have it in the list. So if he has added it, that's okay. That's what you're asking.
Then we can have the authority, Your Honor. You are already finished.
Because I can do it for myself to supply.
Yes.
And I think I'm comfortable.
Yes.
I have the message there.
Yes.
And I got the William one.
Yes. 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 So Your Honor, if I may,
If you tell us the William
it appears there was an oversight, Your Honor, but I know the court was judicial notice of all the citation or all the authorities which we have already provided the citation, Your Honor. So when I was interfered with the floor of my first, I am not in that business like my colleagues. So what you are saying, Your Honor, at paragraph 17, Justice Gigonyo has laid the threshold and also eliminated that interference with witness undermines the criminal justice system and dents the integrity of the criminal process. And he goes on and also says that for such a ground to succeed, the prosecution must tender or must present material information to the head of the court. And the highest decision which we have also cited, Your Honor, the William Chishir case, whereby Justice Mutuku has said that there should be a nexus between the respondent and also the stated interference, Your Honor. So that was the main ground, Your Honor, that has been advanced at paragraphs 9, 10, 11, and 20 of the affidavit. Another look, Your Honor, of the affidavit is that, Your Honor, I will humbly beg to refer you to paragraph 24 of the affidavit, whereby you have been told, Your Honor, that the gruesome murder of the deceased has elicited widespread public anger and outrage leading to demonstrations which at times have been destructive. Hence the safety and security of the respondent cannot be at this point be guaranteed if released on bail. So in order, Your Honor, to demonstrate that such a reason, Your Honor, should not hold water is that we will humbly beg to refer you to the same decision of Justice Gigonyo, that is Republic versus Mercy Jebet, whereby at paragraph 20, which is also titled Safety and Security of the Accused Person, the judge lamented, Your Honor, at paragraph 21, that I have lamented time without number, and again slide into grief. How and why in this age and time should people take the law into their hands to harm the accused? The community herein is within the territorial jurisdiction of the Republic of Kenya, a nation governed by law and order. And under the Constitution of Kenya 2010, I wonder whether the said community will derive the authority to harm or kill a suspect under trial. No one is above the law or should take the law in their hands. All are bound by the Constitution which reigns. and the committee in question should let the law punish the accused. This should stop, and my view is that ground that the security of the accused is threatened by the members of the public or victim family should never, and mark my words, Your Honor, should never be encouraged to be a ground for denial of bail. Otherwise, the court will inadvertently promote or condone violence, disorder, and usurping of law by individuals or group of people. We say no more, Your Honor. Such ground should fail in limine. The High Court has settled the law on that. On the other hand, it is even the duty of the police to also guarantee the safety of the respondent. And we have also been told other issues, Your Honor, that we need time to do forensic, to subject the judges to forensic, etc., etc., etc. We submit, Your Honor, that all those reasons that have been given, it can be done without the need for any custodial order. So we submit, Your Honor, that from all the reasons that have been abused, none is cogent and none should pass the master of the law, because they have already done what they ought to have done, and any proposed investigations can be done without the need of subjecting the respondent to custody, Your Honor. Having submitted the law, Your Honor, that they have failed to demonstrate the reasons necessitating further or continued detention of the respondent, Your Honor, we submit on the second lien, whereby their statute also, Your Honor, has also given the court the latitude of guidance on what you do. And we shall invite you, Your Honor, to consider Section 36, Clause 5 of the Criminal Procedure Code, whereby it is stated that a court shall not make an order for the remand in custody of a suspect under subsection 5 unless there are compelling reasons for believing that the suspect shall not appear for trial, may interfere with witnesses or the conduct of investigations, or commit an offense while on release. So, Your Honor, even submitted that they have not abused that reason, there is a duty that the court also must also satisfy itself before granting any custodial order, that there are compelling reasons that the suspect will not appear during the trial. And there is no such reason that has been advanced by the state, Your Honor. And the other aspect of interference, Your Honor, we have already submitted that there are no material information to persuade you that there is a need to further detain the respondent, Your Honor. And we will say, Your Honor, on the duty imposed on the court in the two-tier threshold, that is the threshold in the second-tier threshold, which is the duty of the court, we invite you, Your Honor, to adopt the reasoning of Justice B.J. Otieno. That is a High Court decision in Ramadan M. Hassan versus DPP. It's a 2017 decision, whereby at paragraph 15 of that decision, Your Honor, it is at pages, you have found that authority. It's at pages 43 to 46 of our bundle, whereby the judge reasons this way, Your Honor, that I must add that a judicial officer before whom an application is presented seeking to limit the enjoyment of a suspect's fundamental freedom akin to the right to liberty is duty bound and enjoined by law and the Constitution to be extra vigilant and not to interrogate whether the facts presented to it merit the dictate and spirit of the law invoked before it and are in consonance with the attributes and real philosophy of the Constitution, which guards against arbitrary and unjustifiable limitation or enjoyment of rights and fundamental freedoms. So Your Honor, we humbly persuade you to adopt that reasoning to be extra vigilant in granting such an application, Your Honor, because this being a temple of justice, Your Honor, you hold that mighty sword of Damascus, and you should always strive for the rule of law and nothing else. So having demonstrated, Your Honor, the two-tier threshold, that it fails in every length, we inversely submit, Your Honor, that on the other hand, there are compelling reasons to release the respondent on bond or bail. And we will humbly invite you, Your Honor, to consider certain factors. Number one, Your Honor, is that the respondent before you cooperated with the investigation. I accompanied him, Your Honor, on the 11th of June 2025 when he was summoned by the Independent Policing Oversight Authority to record a statement under inquiry. And he did so, Your Honor, and he was released. Thereafter, Your Honor, he also presented himself to the DCI headquarters on 13th of June 2025, whereby, Your Honor, he sought assistance to be escorted to the Ipoa offices to seek whether he is required there or not. And indeed, in my company, he was escorted, Your Honor, and he presented himself, and he cooperated, and he agreed even, and he was duly booked at Lamata Police Station, Your Honor. So he has already cooperated, Your Honor. That is a factor which you should consider in granting him, Your Honor. The other factor which we invite you to consider, Your Honor, is that there is already issued in place an interdiction letter which is duly signed by the National Police Service. And Your Honor, in order to put into perspective, an interdiction letter, Your Honor, is a sworn in a real document which sets certain conditions, which is a replica of the conditions imposed under section 36A of the CPC, and also, Your Honor, which technically it holds in abeyance the powers of a police officer. In other words, Your Honor, it removes the thief from him. He can't do anything. And from that interdiction letter, Your Honor, which I had a privilege of seeing as anatomy, that law, Your Honor, he has been told categorically that he should report to the OCS, to the Elliot Police Station. So there is also a condition, Your Honor, to demonstrate that is not a flight risk. There are already safety mechanisms which have been imposed by regard to the interdiction letter, Your Honor. We also invite you, Your Honor, to consider the primary consideration of bond and bail. That is to secure the release of an arrested person, as and when required. And respective of the issues, Your Honor, whether there will be any intended charges or anything, he is still an arrested person within the meaning of Article 49 of the Constitution. And as such, the rights under Article 49 has been activated. And such rights, Your Honor, should be enjoyed to the greatest extent possible. And in interpreting, Your Honor, and in contextualizing the situation, Your Honor, we will humbly persuade you to adopt an attitude that is beneficial to the suspect rather than the state. And in doing so, Your Honor, I will humbly invite you to adopt the philosophy of Justice Kimaru, C. Benwas, in my Confront versus Republic, whereby, Your Honor, it's an affective from pages in pages 22 to 26. Whereby the judge here, at least in this vision, Your Honor, conceptualized and also reiterated the importance of liberty being in pressures that are personal liberties. Right to liberty should be respected at all times unless there are legal reasons for such person to be deprived of his liberty. And the police should only arrest a person when they have a prima facie evidence that an offense has been disclosed which can result in such a person being charged with a disclosed offense. Your Honor, the reason why we are setting this decision for avoidance of doubt is to reiterate the importance of liberty. It's not about the holding charge. So even in their response, Your Honor, they should not deal with the holding charge. This was being, Your Honor, I had a privilege of interacting with this decision, Your Honor, when my then client, Major Rotich, may his soul rest in peace, was arrested and we went all the way to High Court. And the court made certain findings, Your Honor, including one holding charge and his liberty. But the holding charge question, Your Honor, has already been, there is a mutation of law. So that is no longer applicable, Your Honor, and we shall demonstrate the reason why that decision is no longer, the question of holding charge is not applicable, is because of the second decision, which we have also furnished you, that is in Kenneth Omondi, Ocheng, and 38 others, whereby the same judge also reiterated and eliminated the law, knowing that there was a development, because between that Michael Rotich and this Kenneth Omondi decision, Your Honor, there was an amendment to section that 6A of the PC. So we drastically changed the law. That's why we will also adopt the reasoning of the judge that the reason why this court in the Michael Rotich case required a charge or a holding charge or provisional charge to be presented to the court when the prosecution is seeking extension of time was first to inform the arrested person of the likely charge that he or she may face, and secondly to inform the court on the serious nature or otherwise of the charge. So that was the reason in that development of the jurisprudence, Your Honor. So in grounding our application, Your Honor, and also we'll also invite you to consider another factor, Your Honor, that the suspect before you, the respondent before you, is still presumed innocent. That is verse 1 to Article 49, I think 1A, 52A of the Constitution, whereby he is presumed innocent unless otherwise proven. So no matter the veracity, the public pressure or anything, Your Honor, he is still presumed innocent. So we'll also invite you to consider that one, Your Honor. And finally, also we'll also invite you, Your Honor, to consider that is not a flight risk. Yes, fixed aboard, both within Nairobi and also in Eldoret. And it has not even been demonstrated also that is a flight risk. So those are the issues, Your Honor, that we'll humbly invite you to consider in granting him bond or bail, Your Honor. And we'll humbly beg to ground our application on that under paragraph 3 to 5 of the bail and bond policy guidelines, which will guide you especially on the situational analysis. And we'll also beg to ground our application also, Your Honor, and to support the same also as per the decisions which we have cited, which we have already provided. That is the authorities, especially the Court of Appeal in Jayendra Gimji Malde versus Republic, whereby the Court of Appeal settled the issue and reiterated the constitutional provision that an arrested person has a right to be released on bond or bail unless there are reasonable reasons not to be released. And also the Court of Appeal has also reiterated that now, unlike in the past, even those persons charged with serious offences such as murder are entitled to bail on reasonable conditions. And the applicant here is certainly entitled to that bond, Your Honor. And also on that other issues also, Your Honor, which you have been told that there are compelling reasons except the question of interferences, safety and interest, Your Honor. We'll also humbly invite you, Your Honor, to adopt the reasoning of Justice Mativo in Republic versus Danfo Kabage, and I know Malane Senior Cleveland Better also argued that matter, whereby the High Court has laid the test of compelling reasons. That compelling reasons or grounds ought to be proven to the satisfaction of the court, and mere allegations or possibility is not enough, and bail cannot be refused simply because the accused has been charged with a very serious offense, and that the burden of proving such to the court that there is one or more grounds rests solely with the prosecution, and there is no time whereby the burden can shift to the respondent, Your Honor. We'll also rely on the other decisions which we have tendered, Your Honor, the Betty Kimeyua case, which was also a reaction to the Michael Rotich case before the amendment, and we have already furnished to you, Your Honor. And instead, Your Honor, we'll invite you to decline the application before you because the same is bereft of meat and substance to stand on, and to invite you to unleash your sword of Damocles and to strike for the rule of law and to admit the respondent to bond or bail. And we'll humbly, Your Honor, suggest that he be released on cash bail or 7,000 shillings. That is what he can afford, because we also know the conditions of those. And also, Your Honor, in also making your ruling, Your Honor, we'll humbly invite also you, Your Honor, to make certain policy or in your dictum to find or to make certain policy considerations. Because the reason why we are here, Your Honor, is also because of the legal edifice of Ipoa, which is created under the Independent Policing Oversight Authority Act number 11 of 2011. whereby, Your Honor, I wish, as the people of the Republic of Kenya, we had constitutionalized or made Ipoa one of the commissions or independent officers under Article 248 of the Constitution. It would have been good. But what the Parliament did in that act, Your Honor...
Sorry, Your Honor. Sorry. You know, Mr. Keaton is a good friend. He has like a law teacher, like my friend Shadrach Wangui. What he's inviting a court to do, which is now justifying, is beyond the jurisdiction of this court. You cannot make policy. So he should just save us time so that we go to what this court can do. Although he had a very good point, but this court has nothing to do with it.
It was just an dictum observations, Your Honor. And this is why they do that one. They know is that in what the Ipoa Act, what the parliamentarians did was to establish a way that...
Your Honor, we have objected to that time.
It's okay, Your Honor.
This court has no jurisdiction.
I withdraw, Your Honor, and we humbly beg to submit, and I beg to rest my submissions and raise their questions for me.
Okay, thank you.
Thank you.
I've really appreciated your industry.
Thank you, Your Honor.
You brought it so eloquently.
Thank you, Your Honor.
And erudite.
Thank you, Your Honor.
So I believe the others will not have anything to say.
It is Langat. Good afternoon, Your Honor. I will go straight to what my colleagues on the other side submitted earlier in the opening statement, and more specifically on the case of Sudi Oscar Kipchumba versus the Republic. The decision which I believe they will share with you, I've just looked at it and analyzed while sitting here. These are decisions that, in essence, will allow you to dismiss the application today. I'm happy because they are the ones who brought this decision. It's a very beautifully done judgment, ruling. The tests that have been argued by my colleague under Article 49 are found in this ruling. I want to address one or two issues. The first one is the aspect of the investigations. They have made a picture, or they have painted a picture that our client is likely to interfere with investigations. Your Honor, today, the witness, in his affidavit and while being questioned in examination in chief and in re-exam, has told this court that they are in control of certain important exhibits which are not within reach of our clients. There's no way you can interfere with those items, exhibits, which are in control of Ipoa. Your Honor, the second aspect, which I believe will be addressed by my learned seniors, is the aspect which came out in the affidavit, the issue of forensic analysis. The forensic analysis of the phone, the gadgets, will be done and shall be done in the absence of our clients. Ipoa has officers capable of doing that job conclusively without any input from our clients. The attempt by the applicants to say that our client should be in custody while this process is going on should not be entertained by this court. This court, Your Honor, should abide by the binding decision in Professor Ngugi's decision and release our clients on reasonable bail, which my colleagues have suggested, and put even other conditions which our client is willing and ready to abide by. Those conditions, the discretion is with the court. We therefore submit that the application has fallen short of meeting the threshold set by various decisions cited by my colleague and have been supplied to the court, meeting the requirements of compelling reasons. Finally, Your Honor, the affidavit that was filed before this court does not produce, does not even have did not even attempt to convince you for those compelling reasons. With that, Your Honor, I beg rest my case. I'll allow my seniors to have their time. Thank you.
with the greatest of brevity.
Yes.
Kangahi. Your Honor, whereas my good colleagues have examined the veracity of the affidavit at the point, my good colleague, what call him Dr. Kiton, has laid the legal basis, the premise upon which creates a question with the application before you. I'm just reminded before my good colleague, Mr. Ombeta, submits in its finality to say that the application notice of motion that is before you seeks in prayer A, B, C, D. One, that the matter be had inter partes, which is what is happening right now. It is seeking in prayer B, that the respondent be remanded for 21 days pending completion of investigations. It prays in prayer C, that the electronic gadget seized from the respondent be subjected to forensic examination. And finally, any further orders that this honorable court may deem fit. I am certain, and it's a position we take, that we have no objection to prayer C. If the so would want to examine the gadget, given the fact that they are already seized and in custody of the gadget, as to whether we oppose or not, we would not control what they intend. Principally, what Your Honor is being called upon is to give a continuation of detention of 21 days to complete investigations. We submit, Your Honor, that in the deposition of my good friend, Mr. Jibril, that he has since the last 7 days covered 49% of the would-be investigations. I doubt that he would need 21 days to complete the remainder of the 51% of the investigations. Why am I saying this? The persuasion of my good colleagues that, Your Honor, be minded of the provisions of Section 123 of the Criminal Procedure Code, read with the Article 49(1)H, as well as G of the Constitution of Kenya, in matters bail, that you be inclined to admit the respondent to a pre-plea bond condition is the positive aspect that we are all taking, and we have no doubt that Your Honor, clothed with white powers to make such a determined decision on bail bond, would grant. But in the unlikely event that Your Honor is disinclined to grant bail bond as is being prayed, that you consider that the days so requested for 21 days are days which are more than sufficient for them to rely on. We are saying that the custodial detention should not act as a punishment. Given the fact that you've been told the cooperativeness of the respondent and the clear position of the application before you, as well as the affidavit of one Mr. Jibril, which presents before you no evidence that the respondent is a flight risk, no material evidence as said is placed before you that the respondent is likely to interfere with any witnesses or investigations as they are ongoing. But most importantly, that their wish to have the respondent not granted bail is premised on his own safety, and we would only ask is the police saying that they are unable to secure and safeguard the safety and interest of its citizens. In the threshold of that, Your Honor, we plead, like my colleagues have pleaded, that to be inclined to grant the respondent bail bond pending this investigation, and I'm minded that he has been cooperative and no indicator has been placed by the investigators or by way of affidavit that he is likely to become uncooperative moving on forward in this particular investigation. And should in both lean as to whether you grant bail, which we hope you do not, that the days sought for completion of investigation are in excess, Your Honor, and that if they are limited, it would not in any way prejudice the investigations, as nothing would bar the good investigators from making a return to this court and seek extension of more or further time so to conclude the investigation. As we oppose that application, we plead with Your Honor that you admit the respondent to bail bond pending this investigation, and in the event of such disinclinement, Your Honor, be considerate to reduce the number of days that the applicant seeks to hold the respondent in custody. Benign, we submit, Your Honor.
Okay, Your Honor, I was thinking that my colleague Shazia was going to say something. But let me start with if whatever wants to add, you can add. But
You're the last one.
yes. Okay. Now, Your Honor, let me start first of all by asking that let me request that the court, first of all, Your Honor, grants bail to the accused. I mean to the respondent to this matter. Please grant him. And I'll be requesting the court very humbly to do so. Why am I saying this, Your Honor? It's because now I believe that once they have come under Article 49G and 49(1)H, we have an obligation to give you compelling reasons. It's an obligation. It is nothing less than that. Your Honor, if then they have failed in that particular point, what then becomes of that article? Doesn't it become absolute once they fail? And I'm saying they have failed at least miserably today. Why am I saying this, Your Honor? Because if you look at Article 49, and this one was also in the Republic versus Oyama of case, the court has indicated what is supposed to be a compelling reason. That's in paragraph number 23. Tushapatia mengi mkonazi mpaka tumechoka, sio? What does the court say something to do with compelling reason? And this is the Court of Appeal decision in the realm of versus Republic case. It must be something that is forceful, something that is so convincing, something that is so strong that the court cannot ignore it. Cannot ignore it. Now, Your Honor, once we have seen that, then the state has come and told you they want the suspect or the respondent to be in custody because they want to investigate or they don't have access to his phones. What they did not tell you is that he gave them the passwords and they're keeping quiet about it. And if they want the password, we can give it here in court now, so that that point, ya kutaka simu, is out of the story. Let's finish that one. It's a simple thing, a 1 minute thing, doesn't need 21 days. They tell you that there are CCTVs that are within Central Police Station. And that the suspect, the respondent might interfere with them. But the investigating officer has told you clearly they have taken the material that was required. He called it a DVI. That is the most important one. So what they have there is a shell. And that's the reason why they can't pick it, and that's why the OCS here cannot pick it. So that is the second point. That issue about the CCTV, we kill it right now. They have nothing on it. Then they're telling you they are going to interfere with the investigations. But in his affidavit, and what he has said here on oath, is that, in fact, I've given you a password. Take a password. They're telling you.
So we don't have to break it, eh?
Yes, Your Honor. The issue is not about the SIM or the password. It requires a lot of things.
No. Your participation, watching me. I'm running the show.
Okay.
Now, they're telling you about witnesses. They are not telling you the affidavit which witnesses, but they're telling you something else that is imaginary. That they are yet to get some other witnesses who they are going to record their statements. What does that show you, Your Honor? That the OCS does not have the names of those witnesses or does not know them. Does not know them. Such that if we come then to the issue of witnesses and interference with them, it is finished. One of the reasons that the court wants to grant bail to an accused person is whether he's going to appear in court or will appear where is required. Why is this important? Let us look at the antecedents of the respondent here. When the IO here called him, did he appear? Yes. When he was told to go and record a statement, did he appear? He did, and recorded a statement under inquiry.